Hey, Josh, it's great to meet you. Thanks for joining the Building Builders podcast.
Absolutely, Kevin. I'm real happy to be here. Thanks for having me.
Yeah, thanks. I've been quite excited to chat with yourself, and I know we're going to have a little bit of a talk, a bit of a contract talk today. But maybe to kick things off, would love to hear just a little bit more about yourself, your background, and how you got into construction law.
Yeah, absolutely. So I'd have to just start here. I'm a Miami native, so go Miami Heat. I grew up in the South Florida area. I went to the University of Florida, kind of chanced into a construction management degree. Decided that I did not want to be a project manager. I did some internships with some really big general contractors and decided I just didn't want to, go to work on a job site every day. I just didn't have that passion. I used to have a professor that said, you got to love the smell of sawdust and concrete to work in this industry. And I just didn't. But I did really enjoy the business of the industry. So anyway, I actually had a short stint where I was the employee of the year for a small startup for a couple years. But then decided, kind of lost my faith in the product, which happy to say 5 years into Document Crunch, my conviction is actually stronger than ever. Whereas this other product, my conviction was, kind of waned over time. So decided to go to law school, went to law school at the University of Miami, my hometown. And actually 15 years ago this summer, so here we are in, end of May 2023, 15 years ago this summer, I ended up getting a clerkship or an internship while in law school with the preeminent construction law firm in the United States. And I was working in their Miami office this summer, 15 years ago. Also the same summer I got engaged to my wife and now mother of my two kids. But so it was quite a consequential summer. I interned there for a young partner by the name of Adam Hanfinger. And aside from having a funny last name, Adam's name is a memorable one because Adam is now the managing partner of that preeminent law firm in the U.S. and he sits on their executive committee nationwide. And he's actually my co-founder of Document Crunch. So, kind of just nice bookends there. So we'll get back to Adam in a second. But I practiced law in that law firm and another actually law firm for several years in the Miami area where I ended up, having an exclusive construction practice, representing a bunch of really general contractors, but also sometimes developers and also sometimes, trade contractors as well. And 8 years ago, a really large general contractor brought me in-house. So I moved to the city of Atlanta, where I am today, to come in-house with an E&R top 20 contractor. And, I started off in their Southeast business unit, was about $500-600 million in revenue when I started there. When I left there, right as the pandemic was starting, we had eclipsed $1 billion in revenue, and I was leading the legal department in that business unit. And so imagine that I was there during a period of tremendous growth, kind of coming out of the recession and then into kind of, whatever. But was there during a period of tremendous growth. And in that role in particular, I became really just kind of overwhelmed as we were having this growth with a couple of different things that were happening, which led to the founding of Document Crunch. One, I was being inundated with contract reviews every single day. Hey, we're bidding a job. We're one of 4 bidders. We need someone to put eyes on this. Can you help us make sure we're pricing the risk or qualifying our bid appropriately? So that was happening. I actually ended up hiring Adam in my old firm to help me with a lot of that work because I was just overwhelmed with all the contract reviews I had to do. But then you can see there's a transparent, window here behind me in the office I'm sitting in. Yeah. While I was heads down doing the stuff that you would expect lawyers at big construction companies to do, whether it was, negotiating projects over $100 million in value or dealing with a major claim or dealing with HR issues or, working through just big, high risk items, I would have a line of project managers outside my office, outside just like this, pacing outside every single day. Hard hat in one hand, piece of paper in the other hand, knocking on my door kind of a little bit quietly, popping their head and saying, hey, man, something happened on the job site. What do we do? What does our contract say? How do we manage this? And those two pain points in particular, the one that I was experiencing kind of while I was thinking out loud, most construction companies out there couldn't afford to have someone like me sitting in house, being essentially the oracle of contracts, reviewing every piece of paper before we bid it or signed it. And certainly didn't have the resources to be paying someone like my co-founder $600, $700 an hour to do that work.
Right.
Most companies didn't have that in the pre-signature phase. But even for the ones that did, big and small, no one had an answer for all these people pacing outside every single day. And this idea that, our industry struggles with understanding what's in their contracts, both in the back office, but also in the field, and knowing how critically important contract compliance is to ensuring profitable projects, to ensuring that claims don't spin out of control, things like that. Those were kind of the two big problems that really influenced me and inspired me to step out and found this company.
Wow, that's an amazing story. You know what? Maybe we can just pause. I have some more questions, but I'd love to tell me more about your company.
Yeah, so in response to those two problems, right, what Document Crunch is doing today is we're empowering everyone. And when I say everyone, I literally mean everyone in the industry to understand what's in their contracts. And we're doing that in several different ways, and it's quickly evolving where we will go. But the two areas that we're primarily focused on right now are the pre-signature phase. Hey, before you sign this, you should know about these issues. And with a unique user interface, which helps contractors go through like the workflow of bidding a job and negotiating a job and all that. But then also empowering people in the field to make good decisions every single day around, not all the, academic legal issues, but around things like change management and financial management and project execution.
Very cool. Yeah, it sounds awesome. Would love to learn more about that at another time. Are there, through this, have you come up with any sort of terms that contractors should be watching out for? Are there, I'm sure there's probably some that, they're looking at and saying, well, this is just, extra legal stuff that I can probably breeze over in the contract, but there's stuff that people miss all the time?
Absolutely. I mean, there's all the execution and business terms, which are actually, in my opinion, the most important. I mean, it just depends, Kevin, on what area you want to think about. But then, I mean, we now have official partnerships with with Electri, for example. So that's the National Electrical Contractors Association's not-for-profit research foundation. We've given access through this partnership to 30 of their chapters nationwide who are all using Document Crunch every day. And what we're doing is we're understanding where the data trends are in that cohort so that Electri can tell its members how it's performing across the 11 riskiest terms that it considers to be important for its members based on a set of standards.
Okay.
We're doing something very similar with AXA XL, a major insurance company that does SDI, sub-default insurance for big general contractors. We're doing a very similar exercise. So, that's kind of the interesting thing about this, Kevin, is yes, I mean, there's not a lot of variance, having been outside lawyer for dozens upon dozens of contractors and then, spent so much time in-house. There's not much variance between companies of the major issues. So, when I think about when I think about things that I think I would explain at a high level to folks, the concept around consequential damages, right? If you're building a hotel, you're the window installer, and the windows leak. Should you be responsible to, reinstall those windows and maybe clean up any of the damage in the room that ensued, because the window leaked?
Yep.
The direct damages? Or are you willing to take on exposure if that room is out of commission now for 3 months and the hotel was during the Super Bowl and the hotel would have, made $500,000 in profit on that room and now they're coming to you with their hand out? These are the types of things that are very real. And what I would say is, yes, you could breeze over all of them, but it only takes one. It only takes one time for you to never want to breeze over it again. I'll just give you an example. For when I was in private practice, I had a contractor client who was doing work on a Native American reservation on a casino. And one of the trade contractors, I believe the site work contractor, cut an electrical line, which turned off a bank of slot machines for 4 or 6 hours on a Friday afternoon. And we got a spreadsheet from the tribe saying, here's how much we would have made on those slot machines. There's just there's no way I can tell you, because I negotiated the contract for that work. There's no way that I was contemplating what the lost revenues would be if we hit the slot machines, or I've done a lot of work on airports. So if, you're on an active airport site and the airline can't operate the gate, like, what does that mean? These are the types of risks that I don't believe contractors are adequately pricing when they're doing jobs, nor should they be, because they're on the best. These other, entities understand their business and can price around that risk. But my point is, by just taking on consequential damages exposure and not being, aware that a simple mutual waiver of consequential damages, it gets you out of ever having to get that letter.
Right.
All of a sudden you're like, what? What? And waivers of consequential damages, indemnification obligations, are you responsible for anything and everything that happens while you're there? Or are you only responsible for the things that you should, that you did something wrong, to the extent that you did something wrong? Subrogation rights. I recently working with a roofing contractor, and they recently, they're about to go on site, and they have a small scope of work. But what happens if they burn down the entire building? Like, should the homeowners association be able to sue their insurance carrier, sue them for the whole value of the building, even though they already have insurance for it? So there's certainly terms like tied up in the subrogation framework. And I think that, the neat thing about what we're doing at Document Crunch is hopefully we're taking those terms and making them very easy to understand and digest by the industry, so that the industry can make actionable decisions around those big ticket items.
So as a contractor, when you see consequential damages, how do you deal with it? Do you just run away and say, well, there's no way I can't do it? Is there room to negotiate terms? Is there, or do you have to add extra margin in your jobs to be able to cover
the data and some of these data studies that we're doing suggest that, of course, there's room to negotiate. I would say that whether I would run away from it or not really depends a lot on the asset that we would be working on. If I'm doing work on a stadium and that stadium needs to be ready before football season, and the owner is asking me to take on consequential risk, if it's that's a how could you do that? That's just my opinion, of course. Everyone has different risk tolerance. The other hand, if I'm building a small school for a public entity, it's harder for me to wrap my head around the magnitude of what kind of consequential losses they would really have or be able to prove. Whereas, the stadium could easily say, well, this is the amount of 74,000 tickets, average ticket price $100, $7.4 million a game is. I don't know if I got that math right, but it sounds about right. It's either 7.4 million or 74 million. I gotta check that. But anyway, that's kind of how we think about it.
Yeah. So great advice. At least something for everyone to start thinking about. That's for sure.
And I'll tell you, Kevin. I mean, that's the whole point. There's not a right or wrong answer to any of this stuff. It is highly subjective. It's highly dependent on the circumstances. And, that's why, even when I was a lawyer, I felt this way. But at Document Crunch, we don't want to make decisions for you. But we want to arm you with hey, you should be looking at this, and here's some things to think about. And by doing that, you allow people to make good business decisions, like the list of issues that you just went through. Do you run away? I don't know. Do you? Do you price it? Do you try and negotiate it? All these things are fair options to consider.
Right.
But you have to drive that awareness in order to be able to consider those options. And that's what we're really aiming to do. We're not here to say something's good or bad. We're not here to give you advice. We're here to simply say, be aware. Be aware and make a good decision. And that's powerful in an industry that, at least in my experience, Kevin, I've been out here for a while. I've worked, across the table from many smaller contractors or, other stakeholders in the industry that just don't even have that fundamental awareness. And now you're in a situation where you're kind of going in blind, and that's where surprises happen. And of course, that's not good for business.
Yeah. You're essentially, you're providing awareness so that, these contractors can do their own risk management, right? There's a little bit of education here for those that don't have the resources to be able to do it themselves.
I imagine that we have a bunch of customers using Document Crunch every single day. And I would imagine that there are probably numerous times where maybe some of the smaller contractors say, oh, let me pick up the phone and call a lawyer or my insurance broker or someone to help me with this. It's not that you could do everything by yourself. Maybe there's instances where they say, I got it. I've been doing this. I'm comfortable with this. Now I understand. either way, that awareness is absolutely critical. So you at least can
Yeah.
consider options holistically and not make decisions based on limited access to information.
What are the biggest challenges that contractors face when setting up their own contracts?
Yeah, there's a lot right now in this generative AI world about drafting contracts, and so many people are saying like, well, can we do this in the construction industry? Go find me the contractor that gets to draft their own contracts, and I'll tell you that you found the unicorn. Everything rolls downhill in our industry. Owners, like at least in my experience, and like 99% of the time, would source their own contracts. I think the one area that I've seen where it's systematically not this way is like for custom home building. A lot of times the homeowners, the home builders will build, will do the contractor. When I just renovated my bathroom at home, we didn't get to source the contract. But in commercial construction, owners source the contracts, I would say 99% of the time. Then that contract gets flowed down to the or trade contractors from the general, and so on and so on and so on. So I would say the biggest challenge that contractors have in drafting their contracts is that they don't really get the opportunity to draft their own contracts. But I think otherwise, like if I spin your question, I don't know if you've met this, like, plenty of generals draft their own subcontracts. And I think the biggest challenge is ensuring that subcontract, the boilerplate is flexible enough where you can take whatever risks you've bought in the prime contract and make sure that you're balancing them vis-a-vis your sub framework as well, because there's nothing worse in the general contractor's perspective than when the owner has a claim against the general, but the general doesn't have the same claim against the responsible trade partner. That can become a real issue. And I think, similarly, the trade partners oftentimes are like, well, I look at the subcontract, but are you looking at the prime contract? Because there's a really good chance that you're buying whatever's in the prime contract. So again, an awareness issue, but I think that's the biggest challenge, I would say, ensuring that consistency. But otherwise, I would say, go find me the contractor that says they get to draft their own. We should do a poll coming out of this podcast for any of your listeners that are generals or trade contractors. What percentage of them get to source their own contracts to the party, up on the chain? The answer is going to be a small number.
Well, maybe I can give a group, give an example. So by the way, I love your example of the subcontractor there. We do have a lot of listeners that are like smaller contractors working on residential projects. I'll even use myself as an example. Back in the day, I used to have one of the larger landscaping companies up in Ontario, but we did a lot of residential jobs, right? We'd go in, we'd install a pool, we'd install a front backyard landscape. So the contract was kind of on us. One of the things that we used to do is we'd lean on industry associations and take some of their like standard terms. So I think that's kind of where I was building that question from. But I wonder if you work with groups like that.
So I would say that if you had the opportunity to do so, the industry associations and some of the standard templates are while they may not be perfect or optimal, they're certainly a reasonable starting point. And frankly, I believe, again, my opinion, not the rule. I believe in many circumstances those forms are pretty sufficient. I'm sure there's a lot of very high-paid lawyers that if they were listening to this would say, absolutely not. You got to, tweak it. And yes, I get it. To go from good to great, maybe you would need to tweak it. But the reality is, and this, we're all in business now. Sometimes settling for good to get a deal done or to move the deal along is just fine. And I think that those industry forms and templates are pretty, by and large, I'm a proponent of them.
Do you think thinking about the settlements, is a lot of this, does it end up in splitting the difference? Or do people fight right to the very last penny?
You're talking about on the negotiation of the contract?
Yeah. No, so when something goes wrong.
I think it really depends. I think, again, let's go back to this concept of awareness. I think when you have awareness early on of where your strengths and weaknesses are, you can your desire to fight about things should be directly correlated to that. And so, in my opinion, Kevin, is there's very rarely a dispute, which goes to like some of the problem that we're trying to solve for document crunch. Never in my career, having been involved in billions upon billions upon billions of dollars in construction projects, Never in my career have I had a major claim come to my desk and me call that project team in and say, oh, let's see what you got. Put your cards on the table. Never have I said, oh, wow, we're going to crush this. I want to take this to the Supreme Court of the United States. Never.
Right.
Because if there's a dispute, that probably means that somewhere along the way, there became pluses and minuses to that issue, or else they wouldn't be in my office because it would have been settled in the project trailer. Like it would have been
Right.
obvious and it would have just been resolved and done. So I guess my point is, I think that, people that are well positioned in claims have awareness early on.
Yep.
And, I should say threshold to compromise is probably directly correlated to the strength of their claim. I think what you find oftentimes, Kevin, is people go into these like in the contract negotiation without the benefit of a team that did all the right things during the course of construction, which we're trying to help at Document Crunch. B, that not necessarily being communicated fully. And then C, the other side putting their cards on the table at some point in time, and everyone's saying, oh, shoot, we just wasted a lot of time and a lot of money fighting something that maybe we should have compromised, early on.
Yeah.
You also have, I hate to say this, but you also have the more stakeholders that come in that, have, adverse maybe interests. Like there's whole cottage industries that are built around claims and, so all that stuff just adds layers of uncertainty and expense onto things. And again, like it's my fundamental position that if you can arm people with good information at the project level at the onset, like if I was sitting in a job trailer and the owner said, you can't use contingency for that.
Yeah.
Which happens.
Sure.
Maybe there's a situation where I would say, well, hold on. Here is the contract. Of course we can use it. It says it plain as day. What are we talking about? Here's the change order. Sign it and let me go buy you a beer. Like, let's just move. Like, this is like, what are we talking about?
Yeah.
But that doesn't happen because teams aren't confident to challenge in a good way, to push back in a good way, to have a discussion, a collaborative discussion where there's transparency and equal access to information. And that's the difference. So
I love the answer there. That leads me right into my next question of how do change orders and scheduling factor into contract disputes?
Yeah, so I always say, I don't know if this is a PG podcast or rated R podcast, so I'll use a
take it how you want.
I'll use a euphemism. There's a bumper sticker, a very famous one that says "stuff happens." Maybe there's another word for stuff.
Sure.
The construction industry is, in my opinion, Exhibit A, or the shining example of that. Stuff happens on construction projects every day that impact the cost and the schedule. And who's responsible for that stuff happening is completely tied up in what the contract says. We are called contractors for crying out loud. And the entirety of that stuff happening, who's the responsibility or who pays for it, is born in the contract. So when stuff happens, it's predominantly going to impact one of two things at the project level. And you just mentioned both of them, price or schedule. And so the ability to be on top of that stuff, manage that stuff, know who's responsible when, know how to comply, know how to perfect your rights, know how to pull all the right levers so that you leave no doubt.
Yeah.
It's all tied to the contract.
So this kind of gets me thinking a little bit. So it's obviously all tied to the contract, but how do you manage? Do you have any advice for managing relationships? Right, like sometimes, like when you say contract, if you're in that job trailer and you're say a younger company, first 10 jobs as a subcontractor, it's a little intimidating to pull out the contract, right? Like, how do you manage the relationship?
It is. And it just goes back, Kevin, to exactly what we just said. And honestly, we're such a relational industry. I think this is why sometimes teams are so hesitant. But here's my experience. That experience that I just gave you about, well, it's clearly in the contract. Like, what are we talking about? Let me go buy you a beer. I think that this is a good business rule, and it's certainly a good rule in construction. In my experience, when I'm across the table talking to somebody, negotiating with somebody, whether it's over a change order or over who's going to do the next, major financing for Document Crunch or a major customer contract or something like that, When the other party, the counterparty, the person across the table, when they are prepared, when they are taking positions that are grounded in substance, not arbitrary positions, when they're articulating their rationale for why they disagree with something that I've said, human nature is to actually respect, to form respect, to understand, to appreciate that someone is prepared, right? It doesn't mean that you have to fight or be a blowhard. It means that you should respectfully go about operating your business by honoring the deal, or talking about why that deal may not work for you, before you get into the deal. And I think just like anything, I mean, it's probably good like relationship advice for spouses. It's like when you can put things on the table like transparently, grounded in logic, with good reason, it actually engenders respect from the other party. So what I would say, and this is what I used to train project managers, just because you're asking for time or money, that doesn't make you a bad person. It makes you somebody,
right,
and you want to engender that respect from whoever you're working with. So that's my just general. So the advice I would have is don't be unprepared, prepare yourself, and otherwise act in a professional way. Because the minute that you start cutting corners because you want the relationship, just matters to the exclusion of the deal, like that's when you start, creating a dynamic that is more arbitrary in nature, that's more susceptible to things going sideways. And frankly, guess what? When you get to the end of the job, as hopeful and as optimistic as you were at one point in the job, these things tend to always manifest themselves as a bigger deal than they were at the time. Well, you said we couldn't use contingency for this, or you said this wasn't a change order and to just use our contingency, and we're now out of contingency. Well, people tend to forget that happened 6 months ago or a year ago, right? Because money is on the line and people tend to tighten up and pucker up a little bit. And so anyway, my advice would be aware, be professional, be transparent, bring logic to the table. You'll ultimately engender a more respectful dynamic, which will suit you better in the long run, rather than sweeping things under the rug.
So on that, is any advice like when it comes to, say on both sides, timing with, getting the change orders or having that kind of discussion, and then even like timing of payment from the owner to the contractor, any advice here on what to do to sort of avoid some of these legal challenges?
Yeah, so it's negotiation 101. Each change order is an opportunity to change the contract. You're much better off dealing with those one at a time rather than dealing with 40 at a time, right? Because once you have 40 at a time, there's a much bigger, corpus from which you have to, deal with. And now you're starting to think about compromising, or if you just dinked and dunked your way to the 40 rightful change orders, you probably be batting a higher percentage of getting those resolved. So that's the first thing. Again, don't sweep things under the rug. Be proactive. Deal with things in real time. Deal with things when they're fresh in everybody's minds. And then, in terms of the timing of payment on those change orders, look, I mean, cash flow is king for our industry, especially for smaller contractors out there. I think you should be very mindful of what your contract says with regard to the timing of payments and things of that nature. And, the commercial reality is people always pay a little bit longer than we all hope. It's the same in the software world, right? We all have that issue. But again, if you have a good agreement in place that you can stand on, like you have the ability to pick up the phone and say, hey, what's going on? Like, this isn't right. Our agreement doesn't say this. We want to be a great partner. Right. But, like, we need your help. And that's okay. It's okay to do that. Where I think people get over their skis is, you leave these loose payment terms in your contract, then you don't really have a basis to pick up the phone anymore. You're just saying, come on, be a good person. That just doesn't carry the same weight.
So I think I hear you saying, although it can be hard to have these conversations for changeovers, the client will respect you, and you shouldn't procrastinate because they're a whole lot easier to do faster and one at a time rather than procrastinating, wait until the end of the project, you have 10 of them and figure that you'll do this one hard discussion once. Better to have 10 little ones.
You're always going to end up giving more money away if you do it, if you wait till the end.
Are there any are there ever any things that are usually in a construction contract that could be left out, or is good to be overprotected on?
I'm not sure. Are you saying are there items that are commonly left out?
Yeah, are there things that are left out of a contract that should be put in? People forget to put them into the contract.
Well, I mean, we don't need to look past material escalation provisions, right? So like that's a new one. 5 years ago, I wouldn't have worried about supply chain risk or delays due to or delays due to COVID and things like that, and that's now become like a thing. So imagine that, everyone's been talking about that for the last 2 years now, 3 years now. Interestingly, Kevin, we did a study with Electri where in 2023, so everyone's aware of supply chain risk. We did a study of contracts uploaded like in Q1 of 2023 to Document Crunch. I can't remember the exact number, but I want to say that 70% of them did not contain material price escalation clauses protecting people. And so you think about like this idea that like we know that this is likely to be an issue. We're eyes wide open, yet 70% of the time, in a limited data set, it's just on Document Crunch. Still, we got a good amount of contracts coming through Document Crunch, but, and it was a short window of time, but like something like 70%, or maybe it was 60%, whatever it was, 60 to 70% were not protecting themselves. So that's like a really great example of like a recent issue that hasn't always been in contracts. And so if you were just relying on these industry boilerplates or templates, like that's a great example of like where something could just be omitted, because institutionally that hasn't always been the case. So it may not find itself into every contract template ever, created by some of these template providers. But yeah, that's like a great example of like an issue that I don't think is being addressed enough. Sorry, go ahead.
That's wild to me. I can't believe that stat that you just shared. I mean, frankly, there was probably some leeway, frustration from the client side, but some leeway for, change in material costs when COVID started. But, now having 60, 70% of contracts not include this, it's surprising.
So we did this webinar about a month or so ago with the findings of this study. And like the other big thing that was, that had stuck out is there was another study that we didn't do, but we cited it in this webinar, where I think material price escalation cost the industry $96 billion last year. Billion. Wow. Yet contractors aren't protecting themselves from this. Like, it's crazy. And that underscores what we're talking about here, Kevin. Like if I could be in every contractor's office that was about to sign that deal and was ready to mobilize and go on site, I would at least be saying, hey, are we cool with the material prices? Like, how long does our price last for? Like, do we own all the materials already? Are they sitting in our warehouse outside? Or that would at least be a discussion that I would want to have. Again, I'm not saying that in every instance it's necessary that 100% of contracts do this. It's highly dependent upon the circumstances, but I would at least be wanting to raise that awareness. But our industry struggles with awareness when it comes to these issues. And there's just got to be a better way for our industry. Like, to your point, as shocking as that is, the cold, hard reality, and Josh Bone, who's the executive director of Electri, said this. I mean, in this webinar, he's traveling around the country right now, and electrical trade contractors are going out of business left and right over this one issue. Like, that's what it translates to. Like, that's where you take this from a statistic to a reality. And so let me raise awareness here. Like, let's put some faces on it. Good contractors that have been in business for a long time, owned by good families, owned by good people creating jobs, are shuttering their doors over this issue. And that's sad in of itself. Mm-hmm. But do you know what else is sad, Kevin? That doesn't actually serve our industry well in the long run, because the supply chain probably will get under control at some point in time. I don't know if it's in a year from now or 5 years from now or 10 years from now. But if we want efficient construction pricing, if we want a competitive environment, we don't want good contractors going out of business.
Sure.
We want to be able to have the capacity at hand to have great companies that are experienced doing great work. And so it's a real problem, but there's a lack of awareness.
Right.
But there's clearly a lack of awareness still around this issue, and that is where I think our industry has a huge opportunity to be better, and I hope to have a small part in that.
I have one more question, somewhat related to this. So I'm just going to give you an example. I used to, as I mentioned, have a pretty big landscape construction and maintenance company. Part of that, we bid on a lot of government projects, and we'd be committing at least 5 years. There were a couple of big ones where it was like 10 years to maintenance. We're talking about these material escalation clauses. Is there anything to protect a contractor from the escalation in labor costs? I just remember thinking about all of my peers when COVID started, and being so happy that I didn't have those contracts. Like, there's nobody available to work, nobody wanted to, and even now, how do you get people to cut grass? Like,
in this, it's so glad you talked about this. In this webinar, one of the participants actually asked that exact question: is labor the next material price?
Yeah,
and so, like in other words, is this the next thing that we should be contracting around? And I think it's a very valid question, but it's this is the example. These were not things that I used to care. I've only been out of the legal realm for I guess a little over 2 years now, since I've been full time at Document Crunch. These were not things. I mean, 2 years ago I was still worrying about them, or I was worrying about it. But 4 years ago or 6 years ago, the industry was not there. So these were not things that we were contracting around or thinking about it. But that's why this awareness thing is so important. You've got to be paying attention to what's going on out there. And I think that's you're now the second person that's asked that question publicly. And I think there's obviously something to it. And so, maybe that should be the next thing that we should be raising awareness on. Who's going to draft the labor escalation clause and start circulating that for our industry? Maybe we should. And, but these are the types of dynamic or fluid examples where just relying on an old industry template may not work.
Right.
And so I think it's just a great example. The industry is going to continue to evolve, and we need to continue to evolve if we're going to be, stakeholders within that industry.
Awesome. It's super interesting to think about. Josh, this has been great. I want to ask you one more question. We always ask everyone, a little unrelated, but do you have a favorite piece of construction equipment?
Yeah, I do. Actually, that's an easy one for me. I would say my hard hat and my boots. And I would say one, because I've just seen too many times where that hard hat has come in handy, and maybe I've knocked into a couple things while being on site. And two, the boots. I'll tell you a funny story. I went to a topping out party when I was in my legal realm on a very, very rainy day. It was a last minute topping out party, and I was in a pair of, I'd come from the legal thing, and I was in a pair of very expensive, nice shoes. And after going to the topping out party on a muddy site on a rainy day, I will never go on site without boots again. I probably could have had a lifetime supply of boots for the value of the shoes that got ruined that day. So, those are my two things.
They're in your car at all times, I imagine.
Yeah.
Awesome. Thank you. This has been really great. Where can our listeners get in touch and find out more from yourself and Document Crunch?
Yeah, our website's www.documentcrunch.com. Otherwise you could find me on LinkedIn or on social media, Josh Levy, Document Crunch. I'm happy to interact and answer any questions you all have. We're really just here to try and help our industry. I know that our industry can be better. Mm-hmm. I know it. I believe in it, and I'm here to help. Document Crunch is here to help. We want to bring our industry to a brighter, more profitable future. So please engage as much as you would like.
Awesome. Thanks again, Josh. It's been really great.
Thanks, Kevin.